So let me first introduce Professor Colin Reid. He's a professor on environmental law at Dundee University. He also served as a dean of the Department of Law, as member also of the Peer Review College of the Arts and Humanities Research Board, and as a member of lawsuit panel of the assessment of research under the Research Excellence Framework. He serves also as a convener for Scotland on the executive of the Society of Legal Scholars. And as you probably know, and actually you had one of his articles that we sent to you just to prepare this session, his main areas of interest are public law and environmental law, which have put him in a very top academicist in environmental matters. And of course, the impact of Brexit on environmental law, it's also a further area of interest, leading to several appearances at the Scottish and the United Kingdom parliaments, and of course in the involvement in research projects. In those areas, he has extensively published in academic and professional journals. And as I said, one of his articles was sent to all of our audiences. And also, he plays an active role in the environmentalist community in the most general sense, including roles in the environmental law section of the Society of Legal Scholars, in the UK Environmental Law Association, very active, and of course on the Environmental Law Commission of the International Union for the Conservation of Nature. So thank you very much, Professor Reid, for accepting our invitation to, enlighten us today on the Brexit and the consequences on the European Union and the consequences of the withdrawal for the United Kingdom and the and the devolved authorities. Actually, we will have some questions about that. Also, I'm very glad to welcome Mr. Paul Spade, our second speaker. He's a lawyer. Currently, he serves as the head of the unit for environmental enforcement at the direction of implementation and support to member states of the Directorate General for Environment of the European Commission. So it's also, I think that we are very lucky and very glad to have here one of the representatives of the European Commission to talk about Brexit. It was almost impossible to talk about Brexit with no one of the European Commission. We need their knowledge too. So his main expertise areas, of course, it's European Union environmental law enforcement, that's for sure. But as far as I know, he's also an expert in the area of soil quality and sustainable food production, which also it's something which is of the interest of our European, of our Monnet chair. And of course, the most important point is that he was, in fact, one of the persons and present in all the, one of the members of the DG Environment negotiation on all this Brexit deal. So he will, I hope, he can give us some insight from first hand in that sense of concerning not only that negotiation, but also with all these new elements that, the trade and cooperation agreement and, the general view about the general future on that sense. So thank you very much too to share our seminar today. And with that introduction, I will just, we will just start. And I would like first to give the floor to Professor Colin Reid. You have the floor when you want it.
Right, good afternoon. Thank you very much for the invitation. I'm delighted to be able to join you this evening and just sad that I'm not able to be there in person. Hopefully you're now able to see my slides. That's fine. So, yes, what I'm going to talk about this afternoon is, first of all, just give some of the background to Brexit, then talk about the issue of continuity, how laws have in fact been continued in force, whereas in relation to regulatory systems, there's a break in continuity. Then look at how the UK has gone about filling some of the gaps that are created by having left the European Union. Look at the consequences for devolution, which is a very important aspect that the Brexit has particularly brought to the fore, and then some idea as to future policy, although as you'll see, it's pretty much anybody's guess where future policy is going to go. So if we start off just with a quick run through the timeline here, the United Kingdom, sorry, I'll control the slides if that's okay.
Yeah, so, sorry, is there anything?
They're changing forwards and back, so I'll try and do
it. Yes.
So the UK joined the European Communities in 1973, and there was actually a referendum shortly after that on continuing membership, in which a large majority voted in favour of staying in the communities as they were then. Where we are now, though, derives from the referendum on withdrawing from the European Union that was held in June 2016, where by a narrow majority the UK voted to leave the EU, though in Scotland and Northern Ireland the majority were actually to remain. So the leaving majority was centred in England and Wales. After a far too long, far too difficult, far too messy process, a withdrawal agreement was reached in October 2019, as a result of which the UK left the EU at the end of January 2020, but there was a transition period that continued until the end of 2020, during which essentially very little changed. Part of that withdrawal agreement is a set of special rules in the Northern Ireland Protocol, which means that many aspects of the customs union and the single market still apply in Northern Ireland, whereas they don't in other parts of the United Kingdom. And the final step in the chronology is the EU and UK Trade and Cooperation Agreement that was reached at the very last minute in December 2020, but has still actually to be ratified by the European Parliament. It's operating, but on a provisional basis, and theoretically we could, if the European Parliament decided to reject it, we could be back in a whole series of negotiations, which I'm sure would delight everybody. Another part of the background to be aware of, because it affects a lot of what's been happening within the UK, is the UK constitutional background. That the UK operates with a system of devolved parliaments and governments. There's a separate parliament and government in Scotland, Wales, and Northern Ireland. The precise details of their powers differ in each case, but there haven't been any changes in England. What this means is that governmental matters, legislative matters, are divided into devolved and reserved matters. The UK government is responsible for all reserved matters, which includes all foreign relations, including relations with the European Union. Many other matters are devolved, and environmental matters are very largely the responsibility of the devolved administrations. But because there's been no change in England, this means that the UK government deals with some matters for the whole of the UK, where they are reserved matters. In other matters, such as the environment, they're dealing for England alone. So the UK government has these multiple roles, sometimes representing the whole UK, sometimes just England. But this constitutional settlement is not a system of exclusive powers with constitutional guarantees, as you'd see in a federal system, or to some extent in Spain with the autonomous communities. Rather, it's a delegation of power by the UK Parliament. And what that means is the UK Parliament can change the boundaries of devolved power at any time. Equally, the UK Parliament can still legislate on any matter, even those within devolved competence, within devolved power. So although the UK Parliament will seek the consent of the devolved the devolved parliaments before it makes legislation that affects devolved matters, it can still go ahead even if the other parliaments refuse, and that has happened on a number of occasions in the Brexit area. And the final bit of background is just to note the progress for any lawyers who want to keep track of what's been going on. We've had 3 major acts of Parliament that have represented the different stages of the Brexit process. The Withdrawal Act in 2018 that set out the framework for whatever withdrawal agreement was going to be reached. The 2020 Withdrawal Agreement Act that deals with the departure from the EU, and the Future Relationship Act, which deals with the Trade and Cooperation Agreement, passed in an incredible hurry in just in a matter of days at the very end of last year. In terms of the environmental side of things, the response to environmental matters is at different stages in the different parts of the UK. In England, there is an environment bill that's going through the UK Parliament. A very big piece of legislation, does lots of things, but it's been held up both by political issues and by the COVID situation. So although the plans for the bill are clear, the main outlines of it are clear, not all the details are finalised yet. In Northern Ireland, the arrangement is that it will be covered by the same structures as in England under the Environment Bill. Scotland has gone its own way. There is legislation for a new structure for environmental matters in place, but the legislation's not yet fully been brought into force. That's the UK withdrawal from the European Union Continuity Scotland Act 2021. And in Wales, which I won't say anything more about, they have decided to delay their detailed plans until after the elections. In Scotland and Wales, there are elections in May of this year. They decided they'd leave their detailed plans until after the election. Wales already has a much more developed set of environmental governance with environmental principles to some extent already embedded in the setup. So they're in a different place, and I won't say anything more about Wales today. So what happens on Brexit? What's the consequences for environmental law? Well, the first question to think about was what happens to existing environmental law? What was going to happen to all the law on the environment that was either coming directly from the EU, was implementing EU directives, or was influenced by EU law? And it was quickly realized that it was impossible for Brexit to mark a fresh start. You couldn't eradicate, you couldn't delete and replace all the EU law. You had to allow it to continue in force. So the legal position is that existing EU law at the end of the transition period continues in force. It maintains its legal force. So all the EU regulations, all the directives, all the UK laws designed to implement these continue in force. And apologies for the double and I see there. Equally, judicial decisions of the Court of Justice of the European Union, they also remain in binding force in the UK. And all of this category of law, the legacy from the EU, has a special category. It's known as retained EU law, which is subject to some detailed procedural issues, which nobody really needs to bother about. So the effect is that the law continues in effect. Environmental law as it was continues in effect at the end of the transition period. But because it's now UK law rather than EU law, it can be amended at the UK level. There have been lots and lots of technical amendments made to legislation in order to cut out the role of EU institutions. Some of the most boring legislation you'll ever see is some of this legislation just cutting out European Commission every time it gets mentioned and replacing it with the appropriate UK body, and so on. So there's been a lot of amendments to make sure the law can still operate without the EU element being there. European Court of Justice decisions remain binding. They can, as things stand at present, be overruled by the Supreme Court, the highest court in the United Kingdom. but that is going to be extended so that the appeal courts, the one level below the Supreme Court, can also change, can also overrule decisions from the European Court. And that will mean that the law becomes a lot more fluid, a lot more liable to change, because, as we know, in many areas, for example, the nature conservation laws, the decisions of the court have made a major influence on the shape, the operation of the legislation. That will now be subject to challenge, can be changed by the appeal courts, not just the Supreme Court. Obviously, no new decisions of the European Court have any impact in the United Kingdom, except under some provisions in the withdrawal agreement. So any new decisions on environmental matters will no longer bind the United Kingdom. So as far as the law is concerned, the picture is one of continuity. The law just carries over. But in terms of regulatory systems, it's the opposite case. The UK decided not to continue within the EU regulatory systems. So the UK is no longer part of the emissions trading system. There's a separate parallel emissions trading system, but the two systems may be linked in future. The Trade Cooperation Agreement talks about both parties giving serious consideration to joining the two systems. UK is no longer part of REACH, the registration of chemicals process. So again, a separate system has had to be set up, but with complications for Northern Ireland because of its special position. And the UK is withdrawn from the European Environment Agency, but some of the bodies within the UK government are still very much active in the collaborative networks and so on. But the UK has chosen to come out of all these regulatory systems, although the law continues the same. Leaving the EU was recognised as leaving some very significant gaps in relation to environmental law. And one of these was environmental principles, because without the EU treaties, there is no legal recognition for environmental principles within the UK. They were the environmental principles embedded in the EU treaties. Once they had disappeared, there was no longer any legal recognition for the environmental principles. And that gap is being filled for England and Northern Ireland by the Environment Bill. It has already been filled in Scotland by the Continuity Act. These recognise the key environmental principles: integration, the preventive principle, precautionary principle, principle you rectify harm at source, and the polluter pays principle. And the law now says that certain people have to give due regard to the principles in making policy. They apply only in making policy, not in relation to taking individual regulatory decisions, giving a particular permit, giving approval for a development, and so on. But the argument is that, well, if the principles are embedded in the policy should then flow through to the individual decisions. It would be unnecessary to apply the principles in day-to-day operation. It's enough for them to be in the policy. In England and in Northern Ireland, this duty to have regard to the principles applies only to ministers. And what they have to look at is not the principles themselves, but to a ministerial statement that is being prepared. We have the initial consultation draft of that available just now. So it's a limited duty on ministers only to look at the ministerial statement. In Scotland, a broader approach has been taken. The duty to have due regard to the principles in making policy applies to all public authorities, and they are to look at the principles themselves, including looking at how they are being developed in EU law rather than just at the ministerial statement. So environmental principles are now being given legal status across the UK, which they would lack, which they had lost when we withdraw and the treaties no longer applied. The other big gap that was recognised is in relation to oversight and enforcement of the law, because being in the EU provides a strong element of external oversight, external scrutiny of government performance. You have the Commission checking whether the member states are implementing the law. EU law has lots of reporting obligations in terms of the various targets to be met, and so on. People can complain to the Commission where they think a member state isn't living up to its obligations. And whether based on a complaint or something the Commission has discovered for itself, cases can be referred to the court, which has strong power to compel compliance. And this whole system means that there's a powerful informal pressure to make sure that you're living up to your environmental commitments, you're living up to your obligations. All of that is lost on withdrawal of the EU. And this was a major worry, that there would be nobody to keep an eye, to keep a check on the government. And somewhat to everybody's surprise, the governments had agreed to put in new systems to deal with this. At the time of Brexit itself, at the time of the referendum, all the talk was about deregulation, freeing the government from controls, freeing public authorities from controls. But a new minister, pressure from the environmental sector, meant the government recognised that they had to put something in place. And you now have new structures in place, one for England and Northern Ireland, one for Scotland, still waiting to hear from Wales. In England and Northern Ireland, it's based on the Office for Environmental Protection. In Scotland, the new body is Environmental Standards Scotland. Any new body cannot live up to, cannot match the independence and the strength of the EU bodies. Somebody outside the system calling you to account, they have to operate within the system. So independence of these bodies has been a big issue. For the Office for Environmental Protection, the members are appointed by the minister. The minister is going to have some powers to direct the body. In Scotland, there's been more emphasis on independence, in that the members have to be approved by the Parliament as well as being appointed by the minister, and the minister doesn't have this power of direction over what it's going to do. In terms of their functions, the Office for Environmental Protection has a much wider set of functions than is the case in Scotland. It is going to have a task of reviewing progress on the environmental plans that are to be made by the government. It is to have a role in advising government. If it thinks that an authority is not complying with environmental law, it can issue a decision notice telling the body to put things right, and it can refer a case to the court for a review of the legality of what an authority has done. But there's no direct sanction, there's no direct enforcement power. The Office for Environmental Protection cannot get the court to impose a penalty, any fine on a public authority if it's acting in breach of environmental law. In Scotland, Environmental Standards Scotland has a narrower task to review the effective implementation of and compliance with environmental law. Where it thinks there's a problem in relation to implementation, it can make an improvement report, which requires the ministers to prepare a remedial plan. They're accountable to Parliament for what they do in relation to that. Where they think there is non-compliance with the law, Environmental Standards Scotland will be able to serve a compliance notice telling the authority to do the right thing, to come back into compliance with the law, and it can refer the case to a court which can impose sanctions if the authority still doesn't comply. So there's something much closer to the court enforcement system in Scotland than there is in England, but we do at least have some structures to continue to exercise scrutiny over the government to try to make sure that the government, all public authorities, live up to their environmental obligations. As you've seen there, you can't talk about the response to Brexit in the environmental context without thinking about devolution. And environment is one of the biggest areas where Brexit has shown problems, weaknesses in the devolution settlement. The devolution arrangements were made when EU membership was very firmly in place. Because of that, there was no need to worry about certain things, and certain aspects of the devolution arrangements were not fully developed. You didn't have to worry about different parts of the UK doing radically different things that would affect the other parts, because although there was some scope for them to act separately, they had to keep within the limits of EU law. You had a common boundary, a common envelope within which the different parts of the UK had to operate. So where it mattered that there was some collaboration, where divergence was cause problems, the EU limits would make sure nobody did anything too extreme, nobody did anything completely radical. And because so much policy in areas like the environment was being made at the EU level, you didn't have to have a mechanism to resolve differences within the UK. Now, however, you have potential for wide divergence between the different parts of the UK, a situation that's made all the more real by very different policy differences between the different governments. The UK government's emphasis is very much on taking back control. The UK is going to have control of its own destiny, do what it likes, and so on. Scottish government policy, as I'll explain a bit later, is very much to keep in step with EU law. So you have the potential for major differences of direction, differences of policy, and environmental law, being an area that's very heavily devolved, is a likely area of difference, a likely area of where problems will arise. And this background is not helped by the tensions that have arisen in relation to devolution, not least because of the very different political views of the different governments. There are cooperation structures, a joint ministerial council, a number of other arrangements, but they quite simply are not working. They have never worked, and the political differences over Brexit and other things have made sure they're not working properly. And the Brexit process has given rise to major tensions because the UK government in many ways is viewed by the devolved administrations in Scotland, Wales and Northern Ireland as acting without proper respect for the powers, the concerns of the devolved institutions. Initiatives have emerged from London, no consultation with the devolved administrations. The UK government's position on various things is thought not to be reflecting devolved concerns. There is technically no role for the devolved administrations in international relations. And that has all been demonstrated in the Brexit negotiations, where there was no information or consultation with the devolved governments. Now, that's partly because the UK government itself didn't know what it was doing. There was often no consultation with other ministers within the UK government, far less consultation with the devolved administrations. But it's meant that the devolved administrations felt cut out of the whole process. And there's a concern that this will be carried forward to future trade deals. If the UK does a trade deal with the United States, that may have environmental consequences affecting devolved matters, but the devolved administrations may not have a role in that. And this is complicated by a point I made earlier, that the UK government is sometimes acting for the whole UK when it's negotiating internationally, sometimes it's acting just for England when it's dealing with water quality, air quality, and so on. But of course, compared to most countries that have a devolved setup, you have a huge imbalance that England is totally dominant in terms of the UK economy. 80% plus of the UK economy is in England. So you don't have a set of equal partners. You've got the one dominant partner and three much smaller ones, which is, say, it in itself causes problems because many of the solutions to these problems in federal and other countries operate on a basis of much more, not exact equality between the partners, but there's something closer than what we have in the UK. So in terms of resolving these tensions, you've got two different ways of looking at it. Initially, the idea was that you would have common frameworks, that the different administrations, the different governments would come together, they'd agree on common policy in areas where it was important, they would then implement them through their own powers. So you would have the same result across the whole of UK, but each administration would still be making its own law. So you'd have Scottish water quality law, English water quality law, Welsh water quality law, Northern Ireland water quality law, but they'd have agreed in advance what it was going to be so that the law would all be the same. So that's one way you can go, through agreement and parallel legislation. An opposite approach is taken in the United Kingdom's Single Market Act 2020, an act that was passed by the UK Parliament without consent from the devolved parliaments. And this asserts the market access and non-discrimination principles. And what that means is that goods that are lawfully sold in any one part of the UK can access the market in all others. Likewise, services. If they're lawful in one part, they can access the market in all parts. So that if you have deregulation in England, Scotland cannot insist on only goods that meet its own higher standards being available. If something can be sold in England, it can be sold in Scotland as well. And the economic reality is that because England dominates the market, in effect, the English decisions will dictate the position, even in supposedly devolved matters. So although the Scottish Parliament can still legislate, the effectiveness of that will be significantly affected. But it's unclear, is this power going to be used? What's going to happen? There are a number of common frameworks that are in an advanced state of negotiation, discussion, but nobody quite knows what's going to happen in relation to these. And looking forward, various things already in place, uncertainty on others. The new legislation that's coming through on environment matters commits the governments to environmental plans and strategies. The Environment Bill at UK level requires long-term plans and includes a duty to establish legal targets on various environmental matters. And this is going to be monitored by the Office for Environmental Protection. In Scotland, there's a requirement for an environmental policy strategy, but the legislation doesn't require legal targets. It doesn't have the same formal review process as there is in England and Wales. But it does also require a review of environmental governance, including whether there should be an environmental court. So in Scotland, the next couple of years, we're going to have a big review of environmental governance, possibly an environmental court. In terms of wider policy, the Scottish Government is committed to dynamic alignment. That means keeping in step with EU law. Scottish Government policy is to argue for an independent Scotland that will rejoin the EU. So they want to keep in step with EU law so the rejoining process is easy. Northern Ireland, it's already bound to keep in step with many EU rules under the protocol, under the special arrangements for Northern Ireland. UK government policy is unclear, and you keep getting conflicting, contrasting messages from the UK government. You have a very strong rhetoric for wanting to see strong environmental protection. Lots of statements about securing strong environmental protection, about Brexit as a chance to raise standards to be the greenest government we've ever had. There's a clear determination not simply to follow the EU, simply because the EU does something is clearly not a good reason for doing it, as far as the UK government is concerned. But at the same time as you have this talk about environmental protection, you have very strong deregulatory pressure in many areas. Lots of talk about cutting red tape, setting free industry, allowing industry to develop. And in particular, there's a concern, uncertainty about what's going to happen when you come to negotiating new, sorry, something going wrong with slides here. What's going to happen when you come round to negotiating new trade agreements? In order to secure other trade deals, is the UK government going to be willing to lower environmental standards, and what would the implications of that be in the devolved communities? But whatever happens in terms of big policy, I think there's a danger for environmental protection that they'll simply be eroded, that legislation will not be kept up to date, will not be rigorously enforced, that where there are exceptions, where there's discretion within environmental law, it will tend to be exercised in favour of development and industry rather than in favour of the environment. So if you look at the rules on environmental impact assessment, the various nature directives, there's lots of scope for governments to take, authorities to take decisions. You can take decisions that are generous to the developers in deciding whether or not there's going to be any significant effect on the environment. and so on. Lots of decisions have to be taken. There's a danger that they'll be taken in favour of development and industry rather than in favour of the environment. And in the UK system, there's limited scope for the courts to intervene. They look at the legality of decisions on a very formal basis. They're not usually able to review decisions on proportionality. They're not as willing as the European Court has been to intervene to ensure that the broad purpose, the broad objective of the legislation is being satisfied. On top of this, though, we have the added uncertainty of the Trade and Cooperation Agreement. It very much reflects the starting points of the two parties, that there are lots of statements about the parties being entitled to set their own levels of environmental protection, reflecting the UK government's wish to be set free. There's also, though, in there various obligations to try to make sure that this isn't used to undermine competition, to completely undermine the access to the market. So there's an obligation on the parties not to reduce the levels of environmental and other protections in a manner affecting trade or investment between the parties based on the standards at the end of the transition period. But nobody's quite clear what is meant by affecting protection in a manner affecting trade or investment between the parties. Clearly, some divergence, some differences are going to be acceptable, but when is a difference so great that it affects trade or investment between the parties? And this is very much a political question. Only the UK and the EU itself that decide these things. There's no scope for individuals who feel affected to raise it. It's not a legal matter. It's a matter of when the parties are prepared to raise something, when they're going to make an issue of something. Also in the agreement, there are the rebalancing provisions, that if there are material impacts or trade on investment between the parties arising as a result of significant divergences, then things can be taken to try to rebalance to make sure that the level playing field, a fair market, isn't disrupted. Again, though, that's completely in political hands. It's going to be up to the political will of the parties to decide if they're going to use it, what they're going to do. But the rebalancing provisions are quite significant because they allow action to be taken on a very rapid timescale by the standard of trade agreements. So, to conclude, following Brexit, environmental governance has had a surprisingly high profile in planning for the post-Brexit future. At the time of the referendum, everybody in environmental matters was really concerned that all you're going to see was deregulation, deregulation, cutting down of environmental protection. So the fact that things have been done is very welcome. Legal steps are being taken to fill the gaps in terms of environmental principles. We have new oversight mechanisms in place, but arguments, uncertainty over their adequacy still got to see the final position in England. The Brexit process has exposed weaknesses in the devolution settlements, highlighted by the policy differences between the UK and Scottish governments. So that means that the future is far from clear. We're not clear exactly what UK environmental policy is going to do. We continue to have this two-faced idea of strong rhetoric on environmental protection, but lots of things look as if they're heading in a deregulatory manner. We don't know how the Trade and Cooperation Agreement is going to affect the position. We don't really know how the desire for other trade deals is going to influence the position. So, at the end, we come to the same conclusion as in most of my talks on Brexit topics over the last 5 years, which is that really we just don't know exactly where things are going. We don't know what we're going to be. And if we can get any insights from my fellow speaker on how the EU sees this, I shall be absolutely delighted. And just to finish off, that's a picture of the building I should be working in. I haven't been in it this year, hardly been in it for the last 12 months. So it's nice for me occasionally to remember what my workplace should look like, since we're currently still locked out of it. So thank you all very much.
Thank you very much, Professor Reid. Thanks for this interesting and suggestive presentation. Of course, there are a lot of questions. Yeah, probably final conclusion that we don't know yet. It's the most accurate. But yes, indeed, your presentation was full of possible comments and questions. I think the role of the devolved institutions, of course, the principles. I think it goes on the regression principles, on other principles, the gap on the oversight that you also mentioned, the uncertainty that trade and cooperation agreements bring to all this already difficult and complex construction. So let's just keep our questions for our debate. And well, let's now go to see the other side of the of the situation, how the European Commission really faces all this area. And please, Mr. Spade, sorry, I'm not sure of
Spade.
Spade, sorry, Mr. Spade. So you have the floor.
Okay, so thank you very much, and thanks very much to Professor Reed. That was very interesting also to hear from that perspective. So I'm Paul Spate. Yeah, I'm the head of units, and my main day job actually is running the infringement cases that DG Environment runs with the member states of the EU. And I have 10 member states that I look particularly in my unit. But because we had been working on the UK, when the Brexit process came up, we were somehow the ones that knew the issues. So from this, I ended up as the ENV representative on the Brexit, and then I was the main negotiator on the environment in the trade and cooperation agreement, which then finished at Christmas. It was, I'll try and tell you a few stories from it. It was a very interesting experience, if not the easiest year. At points, we sort of worked more or less full-time, weekends, evenings, when it was at its worst. So it's nice to have finished it as well. Okay, right. So what's EU environmental law after Brexit? Well, I think the first main thing that we can bring is we were determined that we could continue in the EU to develop our environmental law as we saw fit, and that Brexit would not get in the way. So this was our main negotiating objective. So what did we need to do that? Right. So, you know, we had ambitions, and we formalized these ambitions at the start of the mandate for the new Commission with the European Green Deal. And the European Green Deal is a very ambitious, it's the most ambitious program we have had in a decade. And it really wants to set new standards for the future in all the areas of EU law. So everything from zero pollution to, you know, legally binding targets on restoration of nature, farm to fork, circular economy. It's very ambitious. So what did we need to do in the Brexit negotiations to ensure that we could keep going? Well, the first thing that we needed to do was, of course, to ensure that we were not going to be undercut economically. You know, it's one thing to tell to our European industry, chemical industry, look, we want you to be ambitious, to substitute chemical products. And then it's another for them to see that just, 30 kilometers away, you have a deregulation, and there's a risk of people being undercut. So this was the first thing we were looking for. The second thing was we were determined not to have a political if you like, a political control, a political restriction. We have the right to regulate. In the discussions, for example, in the trade talks with the US at some point, so I don't know why the slides move backwards and forwards. They seem very sensitive. So the at one point there was a real, there was a concern that we would be able to continue to make environment policy and to apply the precautionary principle. So that was the second thing. And then, we were also trying to make sure that we had the a little bit the systems in place that we could still keep going with our ambitions without Brexit somehow getting in the way. So going a little bit into the detail of the deal. So the first thing to bear in mind is that all of the aspects of the deal, the different agreements, they all apply at the same time. So the Trading Cooperation Agreement does not replace the Withdrawal Agreement. You need to read it all together, which is a shame because it's about 1,300 pages in total. But okay, fortunately, the environment bit is not so long. So you have three main cogs. So you have the Withdrawal Agreement, and very importantly, the Northern Ireland Protocol. So it's part of the Withdrawal Agreement, but it's a very significant part. Then you have now, since Christmas, the Trading Cooperation Agreement, which, as Professor Reid explained, is provisionally applied until the European Parliament ratifies it. And then on top of that, you have a new agreement still to be negotiated, which will be on Gibraltar. And at the moment, you have an agreement in principle between Spain and the UK. And this will then be turned into a mandate for the EU to negotiate with the UK on an EU-UK agreement on Gibraltar, which I will also have the pleasure of doing shortly. So those are the main legal components. And then just briefly to recap, so if you're looking at environment law, for example, if you want to know about the financial provisions, you have to look in the withdrawal agreements. All of the business about the committees, how the UK has left, that's all in committees, that's all in the withdrawal agreements. The procedures for how we are handling our ongoing infringements, that's there as well, and the Northern Ireland Protocol, as I said. But in the Trading Cooperation Agreement, there you have the trade provisions and the level playing field, which I'll explain later. You also have more general cooperation provisions. So this is like a trade and sustainable development. And again, I'll explain that. You have sectoral cooperation. And you also have some deals about how the UK wanted to stay in some union programs like Horizon. So why, the EU, we have loads of FTAs. So one question that we often got from the UK is like, why are you mean to us? Why do you talk about environment all the time in this free trade agreement when you don't have it in, I don't know, the one with Albania or whatever? Well, the short answer is often we do have some environment provisions, but the reality is that, the UK one is geographically very close. We share our air pollution with the UK. In fact, we get a bit more their air pollution because of the prevailing winds. So in other words, it's no good for us if we continue to make an effort environmentally, certainly for the member states that neighbor the UK, if they don't also make that effort. We did, for example, some modeling on what it meant for sort of transboundary air pollution if the UK were to cease any improvements of their air pollution. It would mean that, for example, Ireland would end up having to make 9% more effort to meet its legal target under EU law, just because of the kind of the neighbouring pollution. So this was the first aspect. And the second aspect for why this free trade agreement was so important is because of the fact that our economies are so integrated. All these years of them being in the EU as a member state, they have had consequences, and the result is, the supply chains go backwards and forwards, and it's would be quite easy if you wanted to just deregulate enough to move so that, you have an Amazon, fulfillment center or whatever they call them. You just deregulate enough so they put it there and not here. And this was a real risk. And this is why we put a lot of effort into the level playing field. So coming now to this level playing fields aspects, which is the key parts, our main negotiating objective. So you need to look at it in three different ways. So the first part is what we call non-regression. And here it's, how level is the playing field now? What are they signed up to now? And here, as Professor Reid rightly said, it's important to note that this is completely different from the Northern Ireland Protocol. Here we are not in an issue of regulatory alignment. What the UK and the EU have signed up to is maintaining our standards are levels of protection at the level that they were at the end of the transition period, so at the end of this year. So this is the non-regression commitment. It's you don't go backwards. But it's levels of protection. It's not the details. So, and I'll come on to this in a bit more, you can change things, but the idea is you cannot weaken. As Professor Reid also said, it comes with a trade impact test. So it's not enough. We can't just say to the UK, look, you weakened this law. No, we have to show that it impacts us in terms of trade and investment. Importantly, it also covers the obligation to enforce. So it's not just a paper law obligation. It's not simply that they have to keep their laws in place. They have to continue to enforce those laws, although of course they have a wide discretion as to how they will do it. And then one perhaps very important thing to note about the obligation is it has a very wide scope. Anything which has for aim the protection of the environment. And then we give some examples in the scope. But basically, if the nature of the law was to protect the environment, then they should not regress from it. And it also includes the environmental principles that Professor Reid mentioned. We had a bit of a fight about the wording. It turned out that a minister or the prime minister or someone really didn't like the precautionary principle. They associated the precautionary principle with the EU, and that was a bad thing. So this is why we had a kind of a strange discussion with them, and you'll see it refers to precautionary approach in some parts of the TCA. This is simply for that reason. Of course, precautionary approach was also what's in the original Rio Declaration, so it's clear whatever it is meant, but it was a long and painful discussion. So you have the level playing field now. What for the future? This was the hardest part of the whole negotiation. The UK negotiators and their ministers were determined that in the future they would be able to do what they wanted. They would be free to set their own standards, and to, they kept saying they would be incredibly green, but green in their own way. They would diverge in a green way, or it was like we will be green, but we will make our own mind up on what is green. There was a lot of that. And so we had a very, very tough discussion. And this was the last point that we resolved on the level playing field table just before Christmas, was how to handle this. So what do we have? Well, the first thing, and very importantly, is the 2030 targets that are set in European Union law and therefore were contained in UK law. They are also now contained in the non-regression obligation. So you have waste recycling targets, you have air quality targets, you have some water targets, and the UK agreed that this was part of non-regression. So those 2030 targets, they are committed to seeking to meet. So I think that's a first important part of future-proofing. Then for the beyond that, you have this very novel mechanism, which is the rebalancing measures. So the idea is that over time, we go forward. Imagine we go forward with the European Green Deal. We make a lot of progress. By 2035, we're looking very green. And let's say in the UK, they don't do what they promise and they don't make any progress. Well, then we could say, look, our standards in chemical protection or nature, they are so much higher than yours that we need to rebalance this relationship, and therefore we are going to, block the imports of chemicals into the EU or something. We set a tariff or a quota. Yeah, that's the idea behind it. Of course, that will be quite sensitive, let's say, as to how that happens and when and what. And there are some measures in there that say if it happens too often, there will be a review clause and so on and so on. But that's how it should work in theory. And this is completely novel. This, I think, has never been in any trade deal ever before or since. Okay. And then the third aspect is the governance aspect. Now, in DG Environment, we are once bitten, twice shy. We have had many situations where we have been in a free trade agreement and the wording looks very nice, but the governance arrangements don't work. So, we say, look, this country, they're not doing what they should do. And our trade colleagues, they say, yeah, but it's very hard for us to act and to get them to stop. So here we paid a lot of attention to the governance mechanisms. Now, for non-regression, how does it work? So if the EU or the UK does something bad, we can seize the panel of experts. So we can go to a panel of experts, which is one expert from each side plus an independent, I don't know, Canadian or whatever, and say to them, look, we think that the UK has, they have weakened their level of protection, and that this is having an impact on our trade and investments, and therefore we should be able to, they should cease to do so. And if they don't cease to do so, then we can take kind of penalty measures, again, tariffs and quotas. On the future proofing, it works the other way around. So if we think that there has become an imbalance, we act first. And then the UK, they can either accept, say, yes, okay, it's true, there's an imbalance, we accept your measures, or more likely, they can take us to a panel of arbitration. And the panel of arbitration would say, yes, the EU is justified to take those measures, or no, the UK is not just, or the EU is not justified, or the other way around, of course. And if they do so, then we have to withdraw or modify our measures. So that's how it will work. And these are both completely unique structures, which we've never had before in any FTA. And then the final point is we also have some nice, whoops, I just moved slide. We also have some nice supervisory arrangements. So we have the standard committees, which is a first point of dialogue. So we have like a committee between the two sides. And also, quite interestingly, under Article 7.6 of the TCA, there will be cooperation between the supervisory bodies. Now, for us, this is the Commission. But for the UK, it will be the Office of Environment Protection, and we hope very much Environment Standards Scotland. That's certainly our reading of it. I'm not sure if that reading is shared yet in Westminster, but we will have to see. And I think this is a really good mechanism, because then if there are problems that come up, if we get complaints from NGOs or from trade bodies, we can exchange with them and say, look, we had this complaint. It says your chemical standards is not all that. It's not good. And then they can tell us, no, but we're going to take action or not. And so this is a first way of demining maybe some problems. So this is the governance. And then just to maybe give you a little bit of reassurance, I think up to about 2030, the policy environment is quite favorable to a reasonable outcome. Why? Well, you have all of the dark blue things, which are what's in the deal on the top left-hand corner. But then you have the domestic environment, which are the ones in green on the right side. They will set targets. They have these things in their domestic law. And then you have some other pressures. So the purple, you have kind of policy pressures. I mean, they are still in multilateral environmental agreements. They don't want to be seen as being in breach of the Aarhus agreement. They don't want to be identified as not living up to the air quality standards of the Stockholm Agreement. Yeah, all this stuff. And you have quite a clear commitment in Scotland, as Professor Reid said, to maintaining EU standards. So this will, I think, help a little bit. And then finally, in the protocol, but here they are in full dynamic alignment for the environment legislation that's covered. And I will come to that. More difficult things. If they just decide, if the UK decide tomorrow that they want to shoot all the woodpeckers, I hope they don't. But if they do, we will struggle, because what will be the trade impact on us if they shoot all the woodpeckers? Yeah, hard. These pure nature things like this will be really a struggle. If it's linked to development, okay, maybe we can have a case. But just pure nature protection, that will be a challenge. I'm talking. The other difficulty will be, this is not a difficulty, this is a design feature. If there's a change in regulatory approach, so for example, if they want to move from an air pollution target to an emission trading system, I don't know, for sulfur dioxide or something, and they keep the same level of ambition, they can do this. That's allowed. If you keep the same level of protection, you can change your system. And that's fine. And for us as well, the EU is the same. Single decisions, I think, will also be really hard. If we ban a chemical product and they follow the same kind of processes and they don't ban it, trying to prove that they didn't quite, follow the thing, that will be challenging. Also, all the process elements. The idea is that they have to respect the level, but they don't have to follow all the processes. If they don't want to do noise plans anymore, we will not make them do noise plans, this kind of thing. Or, reporting, obviously they won't do, and management plans, all this stuff. And then one other challenge will be, as Professor Reid noted, they're not in the European Environment Agency anymore, so we won't get any data. and it would be really hard to harmonize. So other than out of the multilateral environmental agreements, that would be the issue, is working out whether they are indeed really in breach of something like an air standard. Okay. So the other point I said that we needed from the negotiation was freedom to regulate. Now, this was quite easy because the UK, they were obsessed by sovereignty the whole time. At one point, we almost started playing, in meetings, sovereignty bingo. You have to see how many times they will say sovereignty, and if you have 17 times, you win. It was almost like that. They really made this argument deliberately over and over and over again. So as a result, there wasn't a problem. So we have the right to regulate fully, clearly in the TCA. We have the right to use the precautionary principle. We also asked them to take the logical consequences of their position. So you want to leave the customs union, you want to leave the internal market, okay, fine, but then you don't cherry pick any elements. So they are not in, they started at one point asking for, maybe we can just stay in the internal market for chemicals. No, you don't just cherry pick the bits you like and then you leave the bits you don't like, not at all. So there's none of that. They're not in any of the internal market processes, and the customs unions are completely separate. If they want to sell a product into the EU, they meet our standards. Basta. Okay, now coming now to cooperation. So this is the third thing that we were looking for, is to see if we could have a reasonable cooperation approach. So you have all the classical, if you follow trade law, then you will see that all of these trade deals, they have called a Trade and Sustainable Development chapter. And here it sets out cooperation on multilateral environmental agreements. You have an article on our shared commitment to international biodiversity, trade and forest, sustainable fishing, all of these normal things. They are all in the in this chapter. What you don't have is cooperation on data, as I mentioned. And then just very briefly, there's also some sectoral regulatory cooperation. This last bit that was kind of left over from their desire to be closer on chemicals, is this annex TBT3, but it's a very light thing. And then there will also be some light cooperation on things like offshore wind farm. I mean, we share the North Sea between us, so there's some provisions in the energy heading on this kind of cooperation as well. Okay, I'll briefly come to climate. Now, I wasn't the climate negotiator. We have a separate climate team and a separate climate negotiator, but I'll just cover it quickly. So there are some interesting elements. For the first time, you have the fight against climate change as an essential element in the deal. And this means if the UK, if they leave, if you have a Donald Trump in the UK and they leave the Paris Agreement, then the whole FTA will fall. It's an essential agreement element, and then the whole thing will be suspended. You have some political commitments towards climate neutrality. So it's presented as a common ambition, climate neutrality by 2050. You have carbon pricing clearly spelled out in the non-regression. This was a big fear of my colleagues, that they would move away from the carbon pricing and this would have impacts on us, and that's clearly in there. For the emission trading system, so at one point they were talking about linking the systems, so the UK system and the EU system, like we have with Switzerland. But in the end, it didn't really happen. There wasn't really the commitment from the UK, or really even the desire from the EU to really do it in the timescale that we had. So for the moment, the systems are not linked, but it's not ruled out. And then there are some issues on aviation fuel taxation as well, which were cleared up. Coming now to the Northern Ireland Protocol. This is quite interesting legally. This is really an unusual animal, the Northern Ireland Protocol. So it basically, what was the aim of it? Well, the aim was to maintain the soft border between Northern Ireland and Ireland. So that people and goods could go across that border, and this was what foreseen in the peace agreement, in the Good Friday Agreement, and so we were determined to maintain that. And in order to have that, well, that means that all of the environment legislation, which is linked to a customs union, and all of the environment legislation that is linked to an internal market, but this has to, Northern Ireland, they have to keep up with this legislation so that we can abolish our land border between the north and the south. And so all of the chemicals legislation, including REACH, all of this legislation about moving trade in endangered species or waste shipments, all of that, this is now covered in the protocol. How does it work? So basically, the UK, they will apply the EU legislation, completely different from the trade and cooperation agreement where they are maintaining a level of protection. Here, they will really apply the legislation. And what's more, it has dynamic alignment. So similar legislation, when it's made in the future, like the single-use plastics directive, this is now being brought in to the protocol because it's part of the internal market. And so we know we need Northern Ireland to apply it. And it's also supervised by the Commission. We have regulatory powers. We can go to the Court of Justice of the EU to say the UK did not do X or Y or Z in Northern Ireland. For the moment, we are in a more tense situation where we are more using political dialogue, but we have those powers. And it runs at least until 2025, and then there will be a vote in the Northern Ireland Assembly whether they wish to stay in the protocol or not. Okay, just to touch briefly on Gibraltar, which is another very interesting one from a legal perspective. So Gibraltar, you have an agreement in principle, not this time on Christmas Day, but actually on New Year's Eve, you had the agreement in principle. So they really left it to the last day. And this agreement in principle is between UK and Spain on how they would like to see the legal relationship around Gibraltar. And this makes it clear that environment is part of that relationship. Now here, of course, nobody is going to put a car factory on Gibraltar. There's no room. I mean, there's no room apart from the rock. You cannot, we are not worried that they will externalize jobs onto Gibraltar, at least in the environment way. The problem here is more about being a good neighbor. And what Spain would like is that, Gibraltar, that they have a functioning urban wastewater treatment system, that they protect the environment, the Mediterranean, and so on and so on. It's about being a good neighbor in terms of environment. And it was already in the Gibraltar Protocol, which was part of the withdrawal agreement, and that lasted for 1 year, and that's now elapsed. And now there will be a mandate for an EU-UK agreement, which will then be negotiated, I suppose, over the next 6 months or so. Let's see. So that will also be interesting. And here we're in a kind of a hybrid model, maybe, whereby maybe it might be more about not so much following the exact legislation, but more about the levels of protection, but possibly dynamically, whereby as the EU improves the legislation that is of interest to that area, that they would maybe follow. But we will see. It's all to be done. Okay, now coming just briefly to some conclusions, and then I'll stop. Maybe just the first thing is, so we have a strange policy environment now. So we have some areas, the ones in red, where the Commission, we are still interacting with the UK as their supervisor still, in the Northern Islands for our ongoing cases, and for the last bits of stuff where the UK is still finishing up its financial arrangement with us, we are still in a supervisory arrangement. Then, under the Trade and Cooperation Agreement, under the level playing field, here we'll be in a more relationship of cooperation between supervisors. So we're still talking about standards, but in a kind of a cooperative way or in a shared way. And then in green, you have boxes where we will be cooperating really like a third country, working together, hopefully, on global issues. That's at least how it should work. So we have all of these different now relationships between the EU and the UK, and different roles for the Commission. Just a few personal thoughts on the relationship in practice, and please maybe don't quote me on these because they are my personal thoughts. I mean, most of what I said is somehow also my personal views, but this is particularly so. So where are we going? I mean, are we in cooperation between the EU and the UK? Well, it would be nice, but I think more likely, I mean, somehow the spirit of Brexit, the whole of the UK government, they are all from Brexit. Yeah, they are people whose careers were based on Brexit. And so for Brexit to be seen to succeed, somehow, in a way, they have to be seen to doing things better than the EU. And this means that if they just follow us, like Professor Reed was saying, if they just follow us and they do what we do, that's not very good, because then what's the point of Brexit? So I think what we might end up better, if it's in a good way, will be more like positive competition. So probably we will say, look, we are going to improve X and Y. And they will say, but look, here we come, we've improved Z. I think it's more like that kind of game that we'll be in. Let's see. We should, however, be able to manage cooperation in the global context. We should be able to work together on the trade in endangered species or illegal deforestation. There's no reason why that shouldn't be possible. The one slight problem is, of course, that the UK, they like to work with their chosen member states. And they don't like so much to work with the Commission because, the Commission is EU and it's bad, whereas, a chosen member state is a friendly member state. They don't really, so sometimes we still have to remind them that they should talk to us as well, because it's an area where we have a lot of competence in the EU. This is still a problem, sadly. At the moment, there is a big issue with the Northern Ireland Protocol. It is very tense. I mean, it's difficult. The UK government somehow is sort of maybe pretending that they didn't sign up to what they signed up to, or that it's quite a tense relationship. So this is not helping. So it will be really important that this stabilizes in order to have a better relationship as a whole, I think, because otherwise it's going to be difficult. So, I mean, again, today, the Commission, we had to take legal action against the UK because they have breached part of the Northern Ireland Protocol, and they intend to continue to breach part of the protocol. So we are not there yet. And then I very much agree with Professor Reed about how we manage divergence and natural drift. Yeah, you have the same chemical decision, you just take it slightly differently. Just normally, just different involved. How will we manage that over time? This is a very interesting issue. And then one thing that we weren't able to deliver is for example, our chemical industry, they say to us, okay, it's nice that you gave us the level playing field, but we have costs that are just deconnection costs. So they say, oh, you can't be too ambitious because, we are managing just the cost of deconnecting via Brexit. I mean, it might be true, but at the same time, well, we need to move forward. And then maybe just to note, the European Parliament, they're watching this very closely. They are very interested in Brexit. I spoke in front of the Parliament Environment Committee, and they are really following this very closely. So that's an interesting one to see how they get involved. And then my last kind of conclusion on the relationship and practice is, so this is a unique deal. The next FTAs, they will not be the same as the EU-UK FTA, but still, I think it has prodded our trade colleagues in the direction of more ambition on the level of environment. So I think the next ones, they will not be the same either. I mean, they will not be like this deal, but they will also not be like they were in the past. Some of this progression, some of these elements, they will rub off, I think, in future trade policy. Okay, so I hope that in our negotiation efforts, all those hours we spent in terrible negotiating rooms in London and in Brussels. I don't know if you've ever been in the Borchardt Center, but it's one of the worst conference rooms you can possibly go in. It's like a kind of a Stalinist bunker. And we spent many, many hours in that. But I think that what we have done is we've been able to preserve EU environmental law, and we have left room for our tree of environment law to grow in the future. And that Brexit will not be constraints on us having the environment policies we need for our citizens. So hopefully we've managed that. Okay, thank you very much.
Thank you very much, Mr. Spade. Really, that's really a unique deal. And of course, I think that with your presentation, you see, I mean, how complex all these issues are, not only, of course, from the internal side, the United Kingdom, but also in the relationship between both the European Union and the United Kingdom. How, well, it looks at least it's a hard experience, and of course, and if there is a success, then it will be a big success, but there is so many areas of risk which are already considerable. So thank you very much for your presentation too. And now is the time that we will open our session and open the debate to all our audience. So I don't know if I would like to invite anyone, I mean, of our audience to to contribute, to ask questions, or to make any comments that you would like to do. I think this is a great opportunity to have here, of course, two top level experts. So you should take the chance. So there is a question, excuse me, on the chat from Professor Alex Peñalver. He asked, I think it goes both speakers, will Aarhus Convention be enforced and developed stronger or weaker in the United Kingdom after the Brexit? So that's it. Please, Professor Reid, if you
I'd
want
say
to start.
that it's likely to be slightly weaker. Recognition of the Aarhus elements are included in the Trade and Cooperation Agreement. The UK is already bound as a matter of international law to comply with Aarhus. But where things go wrong, to the extent that elements of the Aarhus Convention were part of EU law, you had the much stronger powers of enforcement under EU law involving the Commission and the court, and direct rights enjoyed by individuals that they could assert in the courts. Now it's simply a matter of international law. Individuals don't have the same legal rights they can assert in the courts. The UK isn't a monist system, so that international obligations, rights under international law are not part of domestic law unless and until incorporated by an act of parliament, and we don't have one that embodies Aarhus, whereas that gap was partly filled by the EU measures that implemented it. So there won't be a wide-scale departure from Aarhus, but around the edges, around the things that don't quite fit, and when it comes to enforcement, there's much less that can happen than when it was part of EU law.
Yes, many thanks. I mean, I agree with that as well. We did spend quite a bit of time on this in the negotiations. The UK started with the position that, they didn't need to repeat any of this stuff that was international environment law in the TCA because, hey, I mean, it was in international environment law. This was their starting position. But then we said to them, look, this is the first time we have an FTA with another member of Aarhus. Really, we have to at least integrate those provisions into the TCA and have them work. So they are all in there somewhere. You have to look for some of them in Chapter 8 on the Trade and Sustainable Development. It's a kind of an accident of the negotiation that it happened that way, but they are all in, and I think this is quite important because it's linked to the obligation to enforce in a way. I mean, they would have to make a big mess, but imagine they made a real big mess of the right to go have access to justice. Then we could say to them somehow that they had weakened their enforcement mechanism under the TCA. But I think that's not the most likely avenue. Of course, the Aarhus Convention itself has its own complaints mechanism, which is not bad, but it's not binding. I mean, it's more embarrassing for the government if they are taken, and for the EU. We also get taken to the Aarhus Convention mechanism rather than binding on them. And of course, the UK has had a number of cases in the past in front of that mechanism.
Thank you very much. Is there any other contribution? Another one on the chat. Paul Pallas asking, considering past UK role in environmental EU policy, will Brexit allow for a more ambitious environmental policy, or rather the contrary? Yeah, that's also the point, and actually that it's also related to one of the questions I wanted for you too. I mean, I'm just taking that one, so I'm putting also the mind how that would affect the role of the European Commission as a negotiator in the international arena, as far as the United Kingdom, for instance, in the Climate Change Convention or others. It's usually a very active actor, and how that will, I mean, which will be the consequence that will weaken maybe the position of the European Commission somehow. Sorry. Yes.
Yeah, no, I think that's interesting. I mean, I think in terms of the level of ambition, there are one or two policies where it might help a little bit. For example, you mentioned soil policy. You know, they were one of the main instigators in blocking the Soil Framework Directive a few years back.
Yeah.
So maybe it will be a little bit easier now. In other areas, to be honest with you, I mean, there are other member states, sadly, who in the meantime are more negative about the environment than the UK. So, you know, there are Poland and so on that will, you know, continue to play that role of, are you sure? Is it not too expensive? And all these things like that. But I think, you know, there will be some gains, but also some losses, to be fair, because they were also, you know, they were very active on some things. They were very good on, you know, trading endangered species, or also on all this illegal logging. They were very good on all these things. So there will be some, you know, I don't want to be too negative either. There will also be some losses from there, from the departure. In terms of the international negotiations, yeah, it's going to be very interesting because they have at the moment, they have I don't know if it's unfortunate or not, but they have quite a role in the global governance because one, they are chairing the G7. And so there are all these G7 discussions about environment policy, and there, you know, they can pick and choose a bit. And then, of course, they have the COP, the climate COP. And here, yeah, like I pointed out, sadly, sometimes, you know, they have a tendency to, if they want to do something, they go to France, they go to Germany, yeah, they leave them smaller member states to one side, and they certainly don't contact the Commission. So this is a bit of an issue that we have to work out with them, to point out that it's also in their own interest. You know, if they want if they want a coordinated position, then they had better ring the Commission as well. But on the other hand, okay, I mean, we are also very clear that we won't have the tail wag the dog either. You know, we're not going to let them, the EU is a big bloc, and it's not that the EU will continue to have the EU dance one way or another. So this is finding a balance. You know, we want to cooperate with them. There's no reason why we shouldn't have a reasonable cooperation, particularly on these international issues. But there are a few teething problems as well.
Okay, thank you. I also have a question. I don't know. I have a question for Professor Reid too. Sorry if I can. It's about the role of the devolved authorities. I mean, I understand that there are quite important substantial differences between the UK government and, let's say, for instance, the Scottish government. So I was just thinking, to what extent the trade and agreement, the trade and cooperation agreement, may potentially impact on the exercise of this of the powers of the devolved authorities. That may imply kind of a re-centralization or getting that power back, as you mentioned in your presentation. But concerning the how to apply the trade and cooperation agreement for the devolved authorities.
Yes, and there is a real fear that it inevitably involves a re-centralization, that the devolved administrations get one mention in all 1,300 pages of the Trade and Cooperation Agreement. And a point which I haven't seen picked up much is that there's a whole section on good regulatory practice that requires the UK government to speak to the Commission, to Europe, about how things are being done, which in no way recognises that actually the UK government isn't responsible for many of the things that it has to account for, it has to explain, it has to give information about. And as yet, we have seen nothing within the UK as to how the Scottish government, Welsh government, Northern Ireland government are going to be involved in feeding into what the UK does in its relations with the EU. So the UK government has signed up to obligations to deal with things it does not have direct responsibility for under the devolved settlements, but because of the nature of the devolved settlements, if necessary, the UK government can steamroller over the devolved administrations. It can use its powers at Westminster to code things through. I mean, it would be interesting to hear how much this featured in the negotiations, whether it was something that certainly a feeling from many people in the devolved administrations is that large numbers of the civil servants in London just haven't realised devolution took place. They still, 20 years on, they still don't realise there has actually been this change. That's probably a bit unfair.
No, I mean, it's an interesting point. I mean, indeed, I mean, the one thing that we were kind of able to bring in is when it talks in Article 7.6, when we talked about supervisory body, had it refer to supervisory bodies. And the idea was that was, you know, also including, but I mean, there may still be room for haggling over that. And I mean, it is very, of course, it's normal that we were only ever dealing with, if you like, a single position. You know, I suppose it would have been probably quite challenging, just like we didn't, you know, in the negotiation, we didn't have the member states directly sitting behind us. We went back home to get briefed. Of course, we go to the council, we go to the parliament, but they weren't sat there. And I hope that the UK negotiators from time to time also checked in with their Scottish counterparts. But it's very hard to know whether or not they did. It's I mean, we have also, you know, we would like to keep cooperative arrangements going also with the Scottish devolved bodies and with Environment Standards Scotland. So if, you know, if we're able to do so, then that's what we'll try and do. But let's see what kind of response we get.
Okay, so thank you very much. I don't know if there is any questions from the audience. Let me see. So I don't see other questions. I would like to invite our audience to use that opportunity. Okay, so I have another question just during while our audience is still thinking. Well, I just, well, actually those are two questions too. Yeah, the principle of non-regression on the one hand, and yeah, that in fact it's almost, well, it is on the trade and cooperation agreement. But the withdrawal agreement is not just on the political declaration in a very general terms. And actually, I was just thinking also, and if it's only taken into account when it affects trade and investment, as you mentioned. You also mentioned the impact test, and that how that's really may work in real life. I mean, because as you mentioned, there will be some maybe some situations where it's even difficult to identify that impact. That was one question. And another question I really have, because I'm just curious, is about the climate change emission trading scheme and the linking. I mean, do you really think that there is, I mean, as it has been done with Australia, I think, to link the different systems of the United Kingdom and the European Union? I mean, is there a real chance? It was not finally decided because it was not time or whatever, it was too difficult, but it's that in a near future? Sorry, and I'm stopping here.
Yeah, so firstly on the impact test, I mean, I think the first thing to point out is that this is an upgraded version of the impact test. So what we had, for example, with CETA, which is the Canadian trade agreement, this is talking about, you know, they really have to have an intention to impact on the trade and investment. And that, of course, was terrible, because how do you prove that the measure they took was really to try and bring in trade and investment? This is just simply, does it have an impact? And what's more, the other good thing about it, it doesn't say it has to be a significant impact. Yeah, the rebalancing mechanism, that has to be significant, and there's all sorts of words like, that kind of qualifying words. But here it's just, it has to have an impact. So I think if some types of not regression can be quite easily tackled with this, or at least could be tackled. So, for example, if the UK or the EU tries to, change the chemicals regulation, or the air quality, things that are quite easily monetized. You can say this costs you X to do it. So if you stop doing it, this has an impact of X. Those kind of things, I think, we could quite well build a case. More challenging is, like I said, if they just destroy a species or something, or what, I mean, there it would be hard for sure. That kind of impacts would be tricky. If they do as well for specific cases, if we in the past we've had, where we had for example, an infringement case against them about Pembroke Power Station, where they really, really wanted to build a very large gas-fired power station, and they kind of took a few shortcuts through the EIA. If they do that kind of thing, again, I mean, if it's for an investment where, maybe a third party is coming in, I think then maybe we can build a case. And then on the climate change,
can I just say on that, there's also the issue about what that means if one of the devolved administrations did something radically different. It may be a long way away from the EU standards, but given the scale of the economy, does that amount to a sufficient impact on trade and investment between the parties?
Yeah. How do you
into all of this?
Yeah, and I think that's a really interesting point. And I think if it was a concrete enough case, I mean, we wouldn't have to. It doesn't have to be massive scale for us to do it. And of course, don't forget that we can have a kind of a stepped approach. So the idea is, I think, if we get something and we look at it, maybe we get a complaint. We will have in the future we will have a mechanism whereby people can complain about non-implementation of a trade deal. It will go through our trade colleagues, but then it will end up on our desk. This is called the single entry point under DG Trade. You can find it on the on their internet site. And imagine if we get something like that. Well, we will first probably discuss it either in the level playing field committee or maybe with the supervisory bodies, and we will try and see what the situation is. And sometimes that's enough, it has that sufficient chilling effect that they don't do the bad thing that they had in mind, or we don't do the bad thing that we had in mind. Everything is bilateral. So we see, and then I think if it's a concrete case, I don't think it would matter if it was in Wales or in Scotland or wherever. I mean, we consider that only UK has signed up to this deal, and the devolution will certainly not be any kind of excuse in front of a panel of experts.
Yeah, sorry, I was just wondering myself. It's as you said, Professor Reed, too. It has been also discussed at the point and among the different. I mean, the devolved authorities. Is there a debate here too, or just between the devolved authorities and the United Kingdom government, or amongst the
devolved administrations all share the same concerns, that they've been cut out, that they've been left out of this. They are in the dark as to what's going to happen. So they are still waiting to find out how. As I say, because there are these provisions on good regulatory practices and so on, that how is the UK going to organise itself internally to deal externally with the EU? And as far as I know, nothing's emerged in relation to that. I mean, it's not helped by the fact that we're coming up to elections in Scotland and Wales, and we're still waiting for the agreement to be ratified, and etc. etc. But there's nothing. It's still a great blank.
Thank you. And about the linking, the emission trading system, then we also have a chat question too. Sorry.
Yeah, absolutely. I think the issue with it, I mean, the linking could happen. I mean, the bit that speaks to a linking is that climate change is a policy on which the UK as a whole has been fairly consistent and consistently progressive. I mean, you can say, other areas, maybe they're not so strong. For example, just last week we won a case against them on air quality. Still, it was one of those legacy cases that still goes through the system, and they said that in London the air quality, not just in London, Manchester, other places, still does not meet the standards. So you can say that not everything is perfect, but at the same time you can also say that on climate change they are quite consistently ambitious. So that maybe would speak to finding a way. But what's more difficult is, one, the issues that they are wanting to diverge, they're wanting to do things differently. And the second thing is they are a very big player. I mean, they're a big country. So if it has to be in quite a balanced way, otherwise it imbalances our emission trading system. I mean, Switzerland, in the end, that's quite a small country. When we took them on, I think the UK has 40 times more emissions than Switzerland. So if they come in, it has to be in a way that where everything really works and the governance really works. So I have the impression that for the moment we are still in a kind of a wait and see phase on linking or not.
Okay, thank you. So we still have another question on the chat. It's a question from Eva Favares. It's for both sides, but I think it's for both of you. It says, is the possibility of rebalancing measures when going to the panel of arbitration likely to block or undermine the commitments contained in the agreements?
Yeah, it's an interesting question, and we really wanted this mechanism because we were super conscious that we had to future-proof the agreement. I mean, environment policy is an excellent example. It moves on very fast. So if we just had the non-regression and that was it and we went home, what would it be worth in 2035? Yeah, if we're still, not a lot, because by then, the standards will have gone up a lot. So they could sit at their 2020 standard. And by 2035, there would be a big difference if we, assuming that we continue to move forward. So we had to have a future-proofing mechanism of some kind. And this is why we spent, quite a lot of negotiating capital fighting for it, and they spent quite a lot resisting it as well. So it was really an important issue, and then it had to have feasible governance regime. So here the good thing about it is, in the end, if we see there's a problem, even if we see something happens urgently, that they are starting to do a quick action or that impacts the environment, then we can act quite quickly. And in a way it's normal that you have the panel of arbitration, because you have to have a counterbalance in the governance. Otherwise, of course, these very strong powers, the more powers you have, the more governance mechanism you need, right? The more counterbalancing. So I think it is normal. And where I think you're absolutely right with your question is, what will be a problem is if it ends up having to be used a lot, because then that will really destabilize the agreement. So hopefully our regulatory regimes will remain fairly harmonious, because I mean it's written in, you can see that it's written in the agreement that if it ends up being used a lot, there would be a whole review of the economic aspects of the TCA and so on. So that kind of risk is explicitly somehow set out.
Okay. I don't know if Professor Reid, you want to add anything?
I just echo that final point, that the agreement, the hope is that the two parties will get on, that agreements issues will be discussed and go through rather than relying on things formally. The last couple of weeks is not particularly encouraging in relation to that, but maybe that's just a bit of flag waving at the start of the agreement and things will settle down. But yes, I'm not wholly optimistic that things are going forward on the smooth cooperative basis that we'd hoped for.
Okay. I don't know if there is any other question from our audience. If there is not, I will. No. Okay, so I think we are just on our time. So I will just put the final point here. Maybe I think that it was really a very interesting seminar. I'm very grateful to our two speakers, and I think also that if anyone really thought that once the agreements were ratified into force that everything was over, no, that's just the starting point of everything. And we will continue to hear about and to work on those issues and those topics, I think, for quite a long time, I guess. So I think it was really a very, very, as I said, very enlightening presentations and the answer to your questions. So for what I want to say, thank you very much. And we will stop here. I think there is someone, oh, well, I have a final question, if you don't mind to answer it. Yeah, I was just on the final point of the, just the final question is from Juan Orcuela. It says, with the Brexit, will the UK be creating regional environmental agreements to replace the European ones? I think it's referring the point to, I mean, if it will replace the membership to the international environmental agreements as a part of the the European Union, well, to be replaced for the specific international agreements. So there would be.
Yeah, that's an interesting one, isn't it? So I think there's two questions in it. The first point is, indeed, do we need more regional environmental agreements? Because, of course, the Trade and Cooperation Agreement, fundamentally, it's a free trade agreement. It's not really to sort out the cooperation, I don't know, concretely on water policy or whatever, or that kind of thing. But in fact, when you look around, mostly we have those kind of things in place. What is for sure is that some multilateral environmental agreements that were less important suddenly will become more so. For example, OSPAR, which is the North Sea environmental agreement. In the past, that was nearly all EU member states plus Norway plus a few others. Now, this will be the place, if there is marine pollution, this will be the place to talk about it as a regional environmental agreement. So I think that's absolutely true. And also some of the air quality, Stockholm and things like this, they might take on a new importance now that this is the place that we will talk finally to the UK about what levels of air pollution, air quality should we have in the future. And then I think the subset of that one is, so this is a bare bones agreement. I mean, this is what the UK, what they wanted was, they wanted to leave and to have like as hard Brexit as they could. Now, not the whole UK, but the people who were in charge, more or less. And so this is what they got. Basically, you remember the famous Barnier stairs? You saw his slide with the stairs going down from EFTA to Turkey, customs union, internal market. Well, they went to the bottom of the stairs. Okay. Yeah. And then in the future, who knows whether there would be more appetite for a more cooperative role or for closer. I think we are not there yet, but it's true that, for example, it would be maybe it would be nice that we could share some data amongst each other, like we used to do in the environment in the European Environment Agency. But I think not in the short term is the short answer to that one.
Okay, thank you. Professor Reid?
I'd just add that I think in the early days of Brexit, some of the people who were talking about deregulation were seeing everything as coming through the EU, and it had to be pointed out to them that a lot of EU environmental law was actually implementing international agreements that the UK was separately bound to, so that leaving the EU didn't mean you were free to do what you liked. There was this whole network of international agreements that we were bound to. I think that came as a bit of a surprise to some people, because for the last few decades, so much has come from the international agreement through the EU that the direct relationship is forgotten about. And there's a lot of rebuilding to do to rebuild the relationship at UK international agency, international agreement level, but that previously has gone through the EU.
Okay. So thank you very much. I think this is our last question. And now, yes, I would like to thank again to our two speakers today. I think that was a great seminar, very, very interesting for all of us. And of course, to invite the audience to review the session if they wish in our webpage at the Jean Monnet Chair webpage, so where we can find the full seminar, and of course also the PowerPoint presentations. And I think that's all. To thank again our two speakers, Professor Reed, Mr. Spade, for this great afternoon that we all have shared in this interesting topic that I think we will continue to talk about and to analyze and to work on it. So thank you very much. Thank you very much indeed. Thank you.